Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Susanna Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Susanna.
Hi, and welcome to Hull & Estates and Succession Planning. You are listening and possibly watching our podcast today. Today, I want to start off with a bit of a solemn comment and a sad day. We found out today, or I just heard today, that Mark Scott passed away. Mark Scott is a lawyer at the firm of Jenkins & Newman in the town of Whitby, Ontario, and a great colleague of all of us who do estates and trusts work. And his wife, Jennifer Jenkins, and his family are suffering and mourning a terrible loss. Mark was a great guy and a great combatant on litigation and an excellent lawyer, and I know a great husband and a real a fantastic father. So it's a sad day, and we're going to miss Mark. On that note, I wanted to today talk a little bit more about the why. And as I said at our last podcast, I really had some fun reading the book called Start With Why, this book that we've got on our webpage under our current readings list by Simon Sinek. And why in the context of why are we executors? And then more importantly, I think, in some ways, or just as importantly, what does it mean to be an executor? And in Simon Sinek's book, he talks about how important it is for us to consider why we do something, or what is it that we do. Why do we get out of bed in the morning to do what we do for work? Why are we motivated to be a good person? Why do we get interested or disinterested in certain things? And he also talks about in his book the what, and you have to, he says, be very careful that you don't let the what down. So once you've figured out the why, the what is the action items. And in coming into that, I look at the question of why. Why do people want to be executors? And I'm struck every day by the deep concern and sincerity many people have when they get appointed executor. And that strikes me, the why is so important for us as lawyers to remember. It's a tough job, and we're going to talk about in our next couple podcasts how tough it is and some of the things we've got to think about. But the why is almost always the things like, it's the right thing to do, you're the best person for the job, you've been asked by the deceased who's no longer around essentially to do you probably one of the biggest favors you can do for that deceased, and that is transfer that asset on, or those assets on, to whomever that person decided. So it is a tremendously profound choice, and it means a lot to people who get appointed as executor. And so I see every day the why. I understand the why. Lots of times I'll say to my clients, though, are you sure you want to do this? And lots of times clients can just say, look, I'm not sure I want to do it or not, but I've got to do it. So I think a deep understanding of the why helps us really understand the what. What do the day-to-day jobs we're going to be required to do? Because the motivation behind those jobs is often centered around the why. So, forgetting the what and why, and without getting too confusing, let's turn to the what. What does it mean to be an executor? In the past, we've talked about these items, and what we're going to do is we're going to post on our link a link to a list of the what's that we're going to discuss, and some of the other ones. Now, this isn't the list of everything of what an executor must do and must know, but it's sort of considerations of some of the duties as an estate trustee. And those considerations, we're going to try to be, well, we'll certainly be in writing, we're going to be comprehensive on our list, but in our podcasts as well. We've talked a little bit about, really from the point of a passing, when someone dies, what are the obligations as a estate trustee? And we talk a lot about asking our clients to make sure whoever the executor is, A, knows where the will is, and B, what the assets are. But knowing where the will is fundamental. And I tell my clients that because you do often have to move almost immediately. There's the gruesome elements of it. There's a body. a body that has to be dealt with, whether it's in a hospital, whether it's at a car accident, whatever. There is a body to deal with. And the authority for dealing with that body, it comes from the will itself. And certainly in Ontario and Canadian law generally is that the will speaks from death. So one must move, I tell my clients, one must move quickly to assert your authority if need be. And certainly, and Susanna and I, who I haven't mentioned, she isn't here today, but we obviously have had lots of discussions over our podcast as to litigation, and sometimes terrible litigation, over the fight of where the body goes and what it should be done and what internment and what should it be cremated and so forth. But that first step and why the will speaks for death is in large part because someone needs to have authority instantly. And not that you have to deal with bank accounts and assets instantly, but you have to deal with the body instantly. So the first and most, I guess, urgent duty of the executor is to make proper funeral arrangements. The next one that really comes hand in hand, and I guess it's probably, I'm not sure which comes first, the chicken or the egg, but it's of course determine that the will appointing the executor is the last will and testament of the deceased. So you want to make sure, and I tell my clients, well, let's make sure there's no other wills floating out there so that you have the proper authority and that you're working from the most recent will. The third item is to consider, and again, this isn't necessarily in order, and we starts to get a little foggy in terms of, but it forms a bit of a checklist for us as executors. The third is to look around quickly and assess whether or not there's dependents that need to be dealt with. And the obvious one is children, and lots of wills will appoint someone who'd be guardian of the children, for example. And in Ontario, for example, under the Children's Law Reform Act, it's only a 90-day appointment, but that is an immediate determination that needs to be undertaken by the executor. That whole question of whether or not you want to even put a guardianship appointment in your will is something that's debated certainly with young families. There is, in my experience, almost nothing more powerful to delay preparing a will between a young couple is the fight over who's going to be the guardian. And I often will say to my clients, well, wait a minute, it's a 90-day appointment. It's only a short-term stopgap, and if the courts feel that someone other than this should be a proper guardian of the children, then the court will step in. But I'm not underestimating the importance of that. I just don't think it's worthy of stopping signing your will. You can always go back and adjust and make that change at a later date with your will. So I encourage my clients not to have that as the stumbling block. But that's an important thing, assessing the immediate needs of dependents. Now, I've focused on children, but there could be grandparents, there could be adult children, everyone who's around the deceased who could or who is actually a dependent has to be dealt with quickly, because there may be immediate needs to maintain I don't know, payments. Say the gentleman dies in his 50s and he's paying for his mother's nursing home. Well, those payments have to continue, maybe, and probably at law in any event, but it depends on the circumstances, of course, but that's an immediate determination that needs to be made. So we're at the first three items of our list, and it's going to be a comprehensive list that we're going to download as we work through these podcasts to talk about what essentially, hopefully, we're going to come at the end of our mini-series here with a list of considerations of some of the duties of a trustee that we can use as a bit of a checklist once we've taken on that job. So we've decided the why is good, and it's powerful, and it's important to our clients. So in our view, now we have to walk them through the what are the particulars of those duties. So thank you so much for joining me this week. I apologize for having a solo session without Susanna, but we'll welcome her back soon, and thank you.
You have been listening to Hall on Estate and Succession Planning by Ian Hall and Susanna Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.